Listen Up with Jim Potts. Listen up, business owners, CFOs, human resource managers, and all managers and supervisors. Jim Potts is answering and addressing your questions and concerns, helping you stay out of court. Furthermore, please be advised that Jim's answers are not legal advice and are only intended as a guide based on his years of experience. The phone lines are open, 1-855-4-J-POTS. That's 1-855-457-6887. You can also email us at listenup@jameswilliampottsllc.com. Ready to listen up? Here is Jim Potts.
Jim Potts back on the air. Hello, everybody out there in podcast land. I'm glad that you're tuning in to listen to me. Hey, listen. I talk about employers. I talk about employees as well. Send messages out there for employees also. But there's good employers out there, and there are bad employers out there. All my clients are good employers, by the way. We don't have any bad employers as clients. But anyway, the other day I went on the air. I went online, and I found something that I thought was so absolutely ridiculous that I have to share it with you. Now, here's what happened. A federal judge ordered a Philadelphia area publishing company to pay its employees $1.75 million in unpaid wages. Now, what did the company do wrong? Now, listen to this. It docked its employees for time spent going to the bathroom. Now, come on, managers. Come on, supervisors. Come on, employers. I mean, how ridiculous was, I don't even want to mention the name of the company out there that did this, okay? But this is ridiculous. Who takes the time to monitor every time somebody goes to use the restroom? And who writes it down enough to be able to subtract it from their time as part of their break? I mean, that kind of micromanaging, in my opinion, can very easily create a hostile work environment if you're not careful as well. That's ridiculous. And according to the Department of Labor, what happened was the Department of Labor is the one that filed the lawsuit. It's saying the company violated the United States Fair Labor Standards Act because employees weren't earning minimum wage due to the company's policy of requiring workers to clock out while they were going to the bathroom or grabbing a coffee or a smoke. So that's how they did it. All right. I know I didn't tell you that up front, but I thought I'd just leave that out there for you. They actually had them go to their time clock out, and then clock back in. Now, look, that to me is absolutely ridiculous. Now let's just talk about something else for a moment. The smoking thing. The complaints we get from employers are that cigarette smokers, they want to go out and use their own time, or to go out to use time to go and smoke a cigarette. So then the employer tells them, well, you have to smoke your cigarettes on your 10-minute break. So then the smokers want to turn around and say, okay, I'll tell you what. It only takes me 2 minutes, to smoke a cigarette. I can go ahead and do that 5 times, and within that 10 minutes, and it's still the same 10-minute break. No, because what you're not taking into consideration out there, for those of you who are smokers, and don't send me a whole lot of hate mail, don't want to hear it, is that it creates another problem. First of all, it takes you more than the 2 minutes to smoke the cigarette, because you have to get up from your desk, you've got to walk out to wherever the place is that you have to smoke, and then you have to come back. So it's more than just the time that you're actually smoking the cigarette. The other issue that comes up is that it creates a morale problem. Because for those who don't smoke and see you getting up every, whatever it is, to go outside and have a cigarette break, and they have to stay there and wait for their 10-minute break, it does create a morale issue. But anyway, this employer had this policy that they had to clock out. Now, as a result of that, because they were nickel and diming these individuals using the bathroom or grabbing a coffee or smoking, whatever, then it subtracted away from what their hourly wage was. So as a result of that, that's why they were paying them under the minimum wage. Federal minimum wage was $7.25. So they were paying them under the minimum wage, and that's why they had to end up paying the $1.75 million. I mean, that is a lot of cash. So don't make that mistake. Tell people, and there's nothing wrong, by the way, with telling employees, use your restroom on your breaks. But there's situations sometimes where some individuals, I don't want to use the word can't hold it, or they may have a stomach disorder. Guys when they get older, have issues or they may have to use the bathroom a little bit more often or whatever it is. To me, don't nickel and dime employees. That in itself is going to create a morale issue as well. People become disgruntled, and they're going to get even. You may not know how they're getting even, but they're going to get even for that kind of behavior. Now, in that court's decision, the court applied what they call the bright line rule to conclude that whenever a work break lasts 20 minutes or less, it must be paid, no exceptions. Now, if you want to find more about Brightline, just go online, just look up Brightline. I don't want to take the time right now to do it during the podcast, but it's very easy to find. Now, putting aside the illegality of a policy that docks employees' pay every time they go to the bathroom, who in their right mind would want to work for an employer that tracks their every move within the workplace? Nobody wants that. That's another aspect of micromanaging. Now, in my opinion, if an employee is abusing bathroom time, taking excessive breaks to avoid work, doing crossword puzzles instead of taking care of it, etc., then that's a performance deficiency issue that needs, counseling because they're not getting their job done. So that's a whole different thing. And that's okay to be able to follow up with that. So, but to adopt a company-wide policy that docks employees for their time to use the restroom, it's not just illegal, but it's horrendous employee relations. In terms of the relationships that you have with your employees. I mean, don't even go down in that direction. So this particular company, in my opinion, not that I'm going to mention their name on the air, but if they're listening, hopefully this $1.75 million penalty, if you will, for unpaid wages is going to send a clear message not only to you, it also sends a message to other employers. Don't even think about it. Now, there's another issue that's coming up that I want to talk about as well. And it's about employees whose lunch don't need to be paid. Now look, you got to understand that there are state laws and there are federal laws. So paying attention only to state laws sometimes could get you in trouble. Paying attention only to federal laws sometimes can get you in trouble. So what you need to do is pay attention to both. All right. So make sure that you're working with somebody that has the knowledge of state and federal guidelines in both of these areas, because these class action lawsuits always, I won't say always, a lot of times it's going to have to do with pay, overtime, breaks, lunches, things of that nature. So stay on top of that. Now, meal and rest periods are not required by any law that's supposedly, and there's some people out there that say that, but neither federal law requires employers to provide employees with any breaks during the workday. Federal law does not provide for whether meal and rest breaks are counted as hours worked. This distinction is important. If time is counted as hours worked, it goes into the calculation of time worked during the work week for consideration of whether or not the person crossed the threshold for 40 hours worked or not. Now look, rest periods. Rest periods are considered breaks of 20 minutes or less. California law, the majority of my listeners are California. As you know, every 4 hours work, 10-minute break. All right. For lunch, every 5 hours work, 30-minute lunch. The issue that they're going to look at is whether or not the hours that are being worked are there, especially for lunch, is whether or not they are substantially relieved of their responsibilities. There was a case here out of the Sixth Court District of Appeals. Excuse me, getting tongue-tied for a second. They turned around and found that because of the fact that the work was not substantially interfered with. So if they went to lunch and they were not substantially interfered with, it's not a problem. So they're looking at this a little closer now. The person's on lunch in California because of the Brinker decision. It has to be an uninterrupted lunch. So please, employers out there, managers out there, supervisors out there, when somebody's on their lunch break, you cannot interfere with their lunch while they're on their lunch break. So telling them while they're on the lunch break, even though they're continuing to work, that you can, I don't want you working during your lunch break. Arguably, that you're interfering with their lunch. So wait until after the lunch is over and then tell them, by the way, I noticed you were working during your lunch. That violates our policy. I want you to take your full lunch period away from your work area. I do not want you working during your lunch. And you can look that case up also as the Brinker restaurant decision. So keep in mind that an individual has to be totally relieved of their work duties. Now, the Sixth Court Circuit of Appeals fell in line with most of the federal courts in applying what they call the predominant benefit test to determine whether an employee's meal period is compensable. Under this test, the employee bears the burden, though, to prove that the normally non-compensable meal period should be compensable because it's spent predominantly for the benefit of the employer. Now, the key inquiry to always remember is whether the employee engaged in the performance of any substantial duties during the lunch break. And this particular case that came out had to do with Jones and Turner versus Yellow Enterprise, which was they were EMTs, and whether or not they could get their break, not get their lunch because of the nature of their business, is what that was all about. But a lot of times is what they found out was that they were still sitting in their vehicles and they were eating or not eating, and the concern was whether or not they were really getting a bona fide lunch. But if in fact, according to the holding here, they had the opportunity to get out, they had their radios with them, and even though they were just sitting in there was no substantial interference with them being able to take it. So just kind of keep that in mind. It's all about giving them the lunch, not interrupting their lunch, and if they are engaged in a profession like as an EMT, etc., or sometimes it's with security guards and things of that nature, they're going to look at whether or not there's a substantial interference with that 30 minutes worth of during their lunch. Okay, and if you're not sure about these, again, for your particular state, just look up the laws or have whoever your advisor is. And just remember, state guidelines versus federal guidelines could make a difference. All right, with that last comment, it's time to close out this segment, but let me remind you that you can find us on Facebook at Listen Up and subscribe to us on iTunes. Just search for Listen Up with Jim Potts. And as a reminder, we take calls every third Friday between 9:45 and 10:15 at 855-4J-POTS or at 855-457-6887. Either one of those numbers will work. Or you can email us at listenup@JamesWilliamPottsLLC. Also, as a reminder, I'm now on Twitter. You can find me on Twitter. I'll be making comments on Twitter, putting things out there. So sign up for Twitter, as well as I'm on LinkedIn as well. Okay, just look for James William Potts, and I'm out there. Okay, I'm Jim Potts, and I will continue to fight the fight. Thanks for listening. Catch you next time.
Thank you for being a part of Listen Up with Jim Potts. We take your calls every third Friday at 10 a.m. Pacific Standard Time for your questions and concerns. Call us at 1-855-4J-POTS. That's 1-855-4J-POTS. Again, that's every third Friday at 10 a.m. Pacific Standard Time at 1-855-4J-POTS. Like us on Facebook, subscribe to us on iTunes, and link up with us on LinkedIn. You can also email us at listenup@JamesWilliamPottsLLC.com. Until next time, make it a great week.